Okay, today is Monday, February 18. This is Children and Justice, and we are just beginning Learning Unit 3 and wrapping up Learning Unit 2. Now, in 1899, when you had the first juvenile court established, the courts that handled children were based upon the British doctrine of parens patriae, which means the state acts as a parent. And that philosophy is quite different from the criminal justice system. The adult criminal justice system is designed to punish people. Now, different states focus on different areas within criminal justice. Some focus on rehabilitation and less on punishment. However, in 2012, most states around the country, the focus in the criminal justice system, not children, not juveniles, is on punishment. Not in the juvenile system. The juvenile system arises, the juvenile doctrine of jurisprudence arises from the British parens patriae, which means the state acts as a parent. And it was the rationale for the government, for New Jersey, to intervene in kids' lives in a way that is different from the way we intervene in the lives of adults, where we want to punish them. Because children haven't reached legal capacity, their ability to reason well is still developing, and now we know a lot more about the developing brain, and some research suggests that it's not fully developed until 25. We continue to learn that kids are different, and to hold them responsible as if they were an adult would not be in society's best interest. But we knew that way back in 1899 when juvenile courts first began in America, okay? The state had the power and the responsibility to provide protection for kids whose parents were not providing the appropriate care or supervision. The focus is on the welfare of the child. So parens patriae, right there, it's highlighted on the big board. You might want to remember that. The focus is on offenders and not offenses. The focus is on offenders and not punishment. Okay? And that's different from when an adult gets charged with burglary or sexual assault or some other offense. There are some charts in that article, and there are some cases that I want you to be aware of. And they're at page 9 in that article, Juvenile Offenders and Victims, 2006. There's Kent versus the United States. There's in Ray Galt, in Ray Winship, McIver versus Pennsylvania, and a couple of others. The ones I want you to remember are Kent, Galt, and Winship, okay? Those are the cases that I want you to remember.
What's the last one?
Kent, Galt, and Winship, in Ray Winship, up on the big board on the left. And you can tell right away from the language of the juvenile court system that kids are treated differently. As I said a moment ago, the purpose of the juvenile justice system is to rehabilitate kids. The focus of government intervention is that of the parent. So when children stray, when they violate societal norms, we don't punish them, we try to help them, we try to rehabilitate them. We try to make them better citizens. We try to set a good example. We use many of the same tools that we use in the adult system. Juveniles can be taken into custody. They may be held until trial when they're taken into custody, depending upon the nature of the behavior or the offense, its seriousness, and the danger to the community. They are charged. They are sentenced. All those things happen, but we focus differently in the juvenile system. In fact, in New Jersey, children are not charged with crimes, they're charged with acts of delinquency. Delinquency. So the guy who owned the health food store last week, we charged him with a criminal complaint. We took a special piece of paper the state of New Jersey made, and we typed on it, using a computer, what he's accused of doing: a first-degree aggravated sexual assault, a second-degree endangering the welfare of a child. Okay, just like our friend Galloway in the first class. We had to size up whether he gets the more serious endangering or the less serious endangering. Now, he owned a health food store where the kid was a 13-year-old employee. Would he be the less serious or the more serious endangerer under the Galloway analysis? Okay. Galloway said, if you have ongoing, right, substantial, continuous supervision over a child, we're going to treat you the same way as someone who has a legal duty. Legal duty, or you assume the responsibility for the care. Would we need to know more about the health food store owner and the boy's relationship? Yeah. I suspect, and we charged him with the more serious one, that this wasn't a one-day help out, move some boxes in the stockroom. The very fact of his employment suggested that this was continuous and ongoing, and that by hiring him and paying him, this is a formal relationship and worthy of the more serious offense. But his lawyer will argue differently. His lawyer will argue he wasn't supervising him. I don't know what he's going to say. I mean, the kid worked there regularly for cash. But he'll come up with arguments, and we don't know yet. I don't know. Maybe he worked there for a week and left. You know, I don't know exactly. I haven't read all the statements myself. But it's an open issue. But for our purposes, he was charged with the more serious offense. There certainly was probable cause. On a criminal complaint, let's say that 13-year-old boy stole a case of cigarettes, right, from the business. He did it. He's a crime-free young man. I don't want to disparage him, but let's say he stole a case of cigarettes, committed the act of theft, and he was charged in the juvenile court. He wouldn't be charged with a criminal complaint. He'd be charged on a complaint for delinquency. And someone tell me what court he would be in. Juvenile court, which is part of what court? Family court. Very good. Thank you. Family court. So he would be in a different court. He would be charged with a different kind of offense than an adult, an act of delinquency. And at the end of the case, they don't even call it a sentencing. You know, it's all about language. I'm a big fan of language, and we choose our words carefully. And the language of the family courts and the juvenile justice system makes it clear that this is different, that it's rehabilitative. In fact, it's called a disposition. So even if he goes to trial and loses, or is acquitted, the court will engage in what they call disposition rather than sentencing. Obviously, if he's acquitted, he goes home. But if he's adjudicated delinquent, in fact, they're not even found guilty. Here's more language. They're not found guilty. They're adjudicated delinquent. That's what the court does. So they're charged with delinquency on an act of delinquency complaint in the family court, in the juvenile division, and if they're adjudicated delinquent, there'll be a disposition, which is a sentencing. And adjudicated delinquent means found guilty. But we don't use that terminology because the purpose here is not so much guilt or innocence. Okay? It's about rehabilitating the stray child, if you will. Now, the reason why I said I want you to know Winship and Galt and these other cases is because for many years, the family court not only treated the juveniles differently, but did not give them due process, like in the adult courts. You know, in the adult courts, the Constitution pretty much determines how the process works. You got a right to a lawyer, that's in the Sixth Amendment. You got a right to remain silent, that's in the Fifth Amendment. You have a right to a hearing, which is called due process. It arises out of the due process clause of the 14th Amendment and the Fifth Amendment. You have to be proven guilty beyond a reasonable doubt. You have a right to bail. All these things arise from our United States Constitution. Because the reason why due process is so important for adults is because the outcome is severe. You can be placed in a jail cell for many years, sometimes for the rest of your life. Or in some states still, you could be executed. So the laws governing criminal prosecutions are very strict, very rigorous, and there's a lot of procedure involved. And these procedures arose from the colonists' negative experience with the crown in England, with King George and his predecessors. You have a right to be told what the charges are against you. That didn't happen in England in the 18th century. You'd be hauled into a jail cell and they wouldn't tell you what the charges were, and you weren't allowed to have a lawyer, and you couldn't talk to anybody, and you didn't have a right to bail. All those things and many more were part of the negative experience that our ancestors had when they came to this country. That was the negative experience they had from their homeland, England. But when it came to kids, even in the 19th and 20th century in America, the position of government generally was, listen, we're not going to put them in jail. We just want to rehabilitate them. We want to make sure we set a good example and make sure they don't do things like this anymore. So they didn't get a lot of due process. They always didn't have a right to an attorney. Whether they were told of the charges or not wasn't that big a deal. It wasn't that big a deal because the purpose was to rehabilitate them, and that's in everyone's interests. However, over the years, that changed dramatically. Children who are hauled to the juvenile courts for adjudications of their acts of delinquency have a right to full due process. And some of the cases that made that happen are Kent, Galt, and Winship. So let's take a look at them. Kent versus the United States. This case got a kid named Morris Kent. He was 16 years old. He was charged with rape and robbery. He confessed to that rape and the robbery and several other similar offenses. Now, we're going to talk about waiver or being tried as an adult. That came up in this case. The lawyer who represented the juvenile in the 1960s, Morris Kent, he assumed that the family court would consider sending him to the adult system. So he filed a motion on jurisdiction. The court didn't rule on the motion. Instead, they entered a motion saying the court was waiving jurisdiction after making a full investigation. They didn't describe the investigation or the reason for the waiver. Now, let's see what happens here. Let's get past this legalese that I just read to you from the case. The court sized up the charge and they said, we're going to try him as an adult. That's what waiver means. We're not going to try him in the juvenile courts. This is serious stuff. We're going to try him as an adult. The judge didn't say why. He didn't give a basis. And I can say he because there weren't very many female judges in 1966. The judge didn't tell what the reasons were for the waiver. And they had a hearing and he was found guilty later on in criminal court and went to jail for 30 to 90 years. Now, the lawyers for this kid, Morris Kent, said, wait a minute, there was no due process here. The judge said he belongs in adult court, but he didn't provide a basis for it. And they filed some legal papers. And the appellate courts didn't buy it. They didn't want to scrutinize the judge's investigation. They assumed the judge did a good job, even though there's no record of what he did and why he did it. And they upheld the decision to waive him or send him to the adult courts, okay, and go to jail for 30 to 90 years. So now we get the landmark case of Kent versus the United States, where his attorneys appealed to the United States Supreme Court. We talked about that process, right? He started at family court, then he went to an appellate court that was to decide whether there were errors of procedure. The court said, no error of procedure here. We trust the judge. And the lawyer said, well, we disagree. They petitioned for what's called certiorari. You don't have to know this, but it's a legal word, a Latin word that simply refers to the process by which you ask the permission of the Supreme Court of America to hear your case. And very few cases get heard by the Supreme Court of the United States. As I suggested a few weeks ago, they have to be really important, groundbreaking. And this case was, because the Supreme Court decided to hear it. And they said that during that waiver proceeding, the judge didn't make a record. Okay? He was denied his constitutional rights simply because he was a minor. If he was in the adult court and an adult judge made decisions, they'd make a record. And there'd be a hearing, and there'd be evidence on both sides. That didn't happen here simply because he was a minor, so argued Morris Kent's attorneys. The Supreme Court agreed. The Supreme Court of the United States agreed, and they said the waiver was invalid. And what we mean by that is the Supreme Court said that family court judge way back when at the beginning of the case, he said this kid ought to be tried in adult court. The process by which he did that, the waiver, was invalid. He didn't do it the right way. And the conviction and the waiver is reversed. The court ruled the waiver invalid, said Kent was entitled to a hearing that measured up to the essentials of due process and fair treatment. There's that phrase, due process. Morris Kent had the right to be heard, and he had the right to know the basis for the judge's actions. And it didn't happen. More specifically, the Supreme Court said the judge should have provided a written statement. Not only say it in open court, but write an opinion. And he didn't. Now, technically, this Kent decision only applied to courts in the District of Columbia, but around America, they quickly got the message that if you're doing this in Nebraska or New Jersey or Oklahoma or Texas, it's going to be the same result. So, juvenile courts within the family divisions throughout America began to change their procedures. And this began to inform these cases, these courts around America, that you better provide due process to kids. They deserve due process. Just because we're going to rehabilitate them, just because in most cases they don't go to prison, and that wasn't Morris Kent's problem, he went to prison, doesn't mean they're not entitled to due process. This was one of the first cases that began to send a message from the highest court in the land to the trial courts throughout the U.S. that kids deserve due process. Now again, this only applied to Morris Kent. And technically, it only applied to the District of Columbia's family court. Nevertheless, if you're in some other jurisdiction and you pull the same thing as the judge did in the District of Columbia, you're probably going to face the same result. But what was also important was not only did it say that Morris Kent should have had a written statement of reasons why he was sent to the adult court, but that was based upon due process. And what the message was, and when we look at juvenile cases again, we're probably going to look at whether you should have used due process or not. So if it was about going home until trial, pre-trial detention, you don't call it bail with children, pre-trial detention. There's no right to bail for children. In fact, there's an assumption they go home. But if they're a danger, they don't go home. They'll be held in what's called pre-trial detention. But this was all about waiver, right? Waiver is when a kid commits an offense that's really serious that state law says you should be tried as an adult. And the process for deciding waiver in the Kent case was flawed, so said the Supreme Court. and they based it on the Due Process Clause. And why this was an earth-shattering decision around America in legal circles was they used the term due process. So rest assured, next time issues come up in the juvenile courts, you're probably going to have to give the kids due process, whether it's a bail hearing, which is not bail, a pretrial detention hearing, or sentencing, or charging, or notice of what's going on, or an attorney representing them, whether they get a free attorney. All that stuff is in play now. Court didn't say that yet, but around the country in 1966, people were going, hey man, that Morris Kent, when they waived him to be tried as an adult, the court said he's entitled to due process. I wonder if kids are entitled to due process in a bail hearing, or in a sentencing hearing, or in a charging process. And what do you think the answer was? Yes. Over and over again. Till where it got to the point where juveniles get the same level of justice and process as adults do. They're treated differently, the process is different, but the procedural aspects of it, the constitutional aspects of it are virtually identical. Virtually. There are some exceptions to this day. For example, children are not entitled to jury trials. There are no jury trials in the juvenile system. There is no bail. Not because we want to treat kids differently than adults. Seems like adults get a good deal because they can get out on bail. No, the assumption is kids go home. But sometimes kids got no home to go to. Or the home they go to is not a home that is conducive to public safety. There's no one there to supervise them properly. Now, maybe you put them in a foster placement. Maybe you make different arrangements. But sometimes entangled in that is the kid's dangerous. Without an intervention, without rehabilitation having started and impacted him, he may hurt people. So he may be held in pretrial detention. So that's different. Kids are assumed to go home, but sometimes they can't. No bail, you stay at the detention center until your case is heard. That's different. No jury trial. That's different. There are a few other things. But in most situations, kids are entitled to the same due process as adults. And in Ray Galt is probably the most famous decision ever in the juvenile justice system, even more important than Kent. Now, this was an Arizona case. You had a 15-year-old kid, and he was already on probation for juvenile offense. In 1964, he made a phone call to an adult neighbor and told her, "Are your cherries ripe today? Do you have big bombers?" A crank call to the neighbor. The neighbor knew who it was. He wasn't the most sophisticated crank caller. And they picked up Gerald and they brought him to the detention center. She apparently knew his voice or whatever. We don't know, because the problem was she didn't come to the hearing. He's charged with this crank call, whatever the offense was, harassment, I don't know what it was in Arizona in 1964, but he was charged with the crank call, with an act of delinquency. And then they want to adjudicate it. Did this happen or did it not happen, right? They want to adjudicate it and dispose, give him a disposition, try to rehabilitate him. Well, before you can rehabilitate him, you got to find out if he did it. We call it a trial in adult court. We call it an adjudication hearing in juvenile court. Well, the lady with the cherries down the block, she didn't come to the adjudication hearing. And the court never ruled on whether Galt made these obscene remarks. I think obscene was an element of the offense that he was charged with. So, if you're going to charge him with making obscene remarks, you need to make a finding that they're obscene. In order to make a finding that they're obscene, we need to know what they are. There's some of them in the record here, but the judge certainly didn't resolve the issue of the obscenity of the remarks at the trial level in family court. Galt was sent to the state home for boys in Arizona for the period of his minority, which meant back then he went to the state home for boys till he was 21. If he was accused of this as an adult, he would have gotten a $50 fine, maybe 2 months in jail. Now, we understand that the purpose of the juvenile justice system is rehabilitative, not punitive. Nevertheless, with such a striking disparity in outcomes, this became an important case and a well-known case. And it was written about not only in legal journals, but in the New York Times and the Arizona newspapers. They say bad cases sometimes make bad law. And this was a bad case. It didn't pass the smell test. Something's wrong here. So, Galt's attorney files what's called a writ of habeas corpus. Don't worry about that. That just means eventually he gets to the United States Supreme Court. The central issues in the case were whether Gerald Galt, the 15-year-old, had any constitutional rights. Remember, the assumption was that they're different. We're not punishing kids. Till the day that Gerald Galt wound up in front of the Supreme Court, from the day Gerald Galt wound up in front of the Supreme Court, and for all time before that, there were no constitutional rights for children. However, in the Galt case, the right to notice of charges, counsel, questioning of witnesses, protection against self-incrimination, a transcript of the proceedings, and appellate review, they were all denied. Those are adult rights, and kids didn't have them. Now, the court changed everything in the Galt case. The court ruled that in hearings that could result in commitment to an institution. So that's an important phrase. If you might go to the state home for boys or be locked up somewhere, committed somewhere, you have the constitutional rights that everybody else has. And you're not denied them simply because you're a child. The Galt court based its ruling upon the fact that he was being punished rather than helped by the juvenile court. They rejected the parens patriae principle as murky and dubious and not really helpful. Although we still talk about it and it's still very important even in 2013. Okay? The court said, well, we're not going to base how we treat our children on that old-time notion. They concluded that it violated the due process clause of the 14th Amendment. And even though the juvenile courts may be acting benevolently, that is, in a helpful way, that is a poor substitute for principle and procedure. Okay? A poor substitute for principle and procedure. So why is Galt such a big deal? It's right here. I'm going to highlight that on the big board, and I want you to focus on that for a minute. I have to step outside for a second. Okay, who wants to tell me about Winship? What changed? What did Winship change that Galt didn't and Kent did not? Go ahead.
The standard of the reasonable doubt as opposed to just, no wait, hold on. Because it's, people were going on...
you were going to say it before, the standard of what?
The standard of the evidence, what had to be done.
Yeah, we call that the standard of proof or the burden of proof. And before in Ray Winship, what was the standard of proof in juvenile proceedings when you were accused of an offense that would be criminal if you were an adult? What was the standard of proof? Preponderance of the evidence. Very good. Can someone tell me where else we see preponderance of the evidence as a standard of proof within the family division? Well, the world doesn't know who you are. I'm teasing you. Within DIFUS or DCPP, child protection. Not for all hearings, but for that fact-finding. That fact-finding, the standard of proof is preponderance of the evidence. We'll talk more about burdens of proof later. And that is a lower standard. It simply means that the judge in a juvenile case, or if it's an adult proceeding, if there's a jury, which there wouldn't be, but the judge has to be convinced by a little bit more than halfway, 51%. preponderance means that the evidence that shows that the child needs protection, for example, in child protection, there's a preponderance of it. It preponderates a little bit more. Beyond a reasonable doubt, and for the record, I'm moving my hand towards the ceiling with my right hand and towards the floor with the left. Beyond a reasonable doubt, the judge or the fact finder, the jury perhaps, needs to be really, really convinced. Beyond a reasonable doubt. Okay? And Winship involved that 12-year-old. Different kid. This kid was 12. He was charged with stealing $112 from a woman's purse in a store. Supposedly was an eyewitness. He was adjudicated delinquent, which we now know means he was found guilty and committed to a training school. That's a euphemism for they sent him to jail for kids, the kids' jail. They called these prisons for children training schools. In fact, in New Jersey, at Jamesburg, we still call it the state home for boys. And quite a home it is. The New York juvenile courts operated under the civil court standard of a preponderance of evidence. The court agreed that he was entitled to reasonable doubt standard. On appeal to the United States Supreme Court, the central issue is, as you all stated, whether proof beyond a reasonable doubt was required. The court rejected lower court arguments that juvenile courts were not required to operate on the same standards. Again, going back to this parens patriae, because they're designed to save rather than punish children. The court said reasonable doubt standard is involved in all delinquency actions. All of them. So, things changed. Now, here from 1965 to 2005 is a list of all of the landmark cases in juvenile justice. I want you to remember Kent, Galt, and Winship. However, Breed versus Jones, Smith versus Daily Mail Publishing, Eddings versus Oklahoma, Schall versus Martin, and the others are important as well. Schall versus Martin's an interesting one because that addresses the bail issue. Pretrial detention of juveniles is allowable under certain circumstances. We don't do that with adults. We treat kids differently, but I told you why a little while ago. You remember when you get a kid and the family life is unstable and he's got to be somewhere and you can't find a foster placement that's secure enough or some alternate placement and he's a risk or she's a risk, we're going to keep the kid safe and in detention until the thing is adjudicated. And then we'll figure out, how best to rehabilitate. Most recent cases, Roper versus Simmons, 2005, established a minimum age for the death penalty at 18. So you cannot execute people under 18.
Wasn't there just something where it was age where juveniles can't be sentenced to life or...
Yes, there's been some recent developments in the United States Supreme Court involving juvenile offenders, and I think it may have had something to do with whether life imprisonment is an appropriate sentence for a juvenile in certain circumstances. I'm not sure.
And it's still state by state. It's not...
Well, I'm glad you bring these things up because you read the papers a lot, and I like that because I read them every day. I want you to find that and put it in the cyber cafe. You don't have to analyze it. No, you don't have to analyze it. You don't have to think about it. Just find that case and post it in a cyber cafe. But that's a good point. We ought to know that case.
Which case is it?
Well, I don't remember what it's called. I look it up.
You don't have to know it. It's just something she's going to put in a cyber cafe.
The case that is changing, like juveniles getting life sentences, and there's still some issue over whether it's across the board or states have discretion.
Yeah, the Supreme Court is still deciding cases involving whether kids get treated the same way as adults in the courts. And she made the observation there was a recent case where they said that we think that kids they can't get the death penalty. We know that. Adults can. And they may not be able to get life in prison. in certain circumstances. And that was very recent. The Supreme Court did something on that. She'll put it in there. It's not going to be on the exam. It's just so we know more and we learn. Statutes set age limits for original jurisdiction of the juvenile court. Some courts define children as over 16, or over 17, or over 18, or over 21. There's some variability among the different states concerning at what age you go to the juvenile courts and at what age you go to the adult courts. And that section of this article talks about that. What I do want you to think about is waiver. We're not going to talk about that today. I don't think we'll get to it. We'll talk about it next week, and I'll explain to you what it is, generally speaking. We'll talk more about how it operates in New Jersey, okay, later. But that's the thing where a kid gets charged with a murder and rape. He's 15 years old. Do we try him as an adult, okay? In fact, it's the subject of your discussion board, I think. Pretty sure. Double check. It is, right? All right. Yeah, Learning Module 2 discussion board. No, it's Learning Module 3. Okay, good. Thank you. Now, how kids get into the family court differs around the country. Local processes differ around America. Some law enforcement agencies may divert juvenile offenders from the justice system. So, and New Jersey has this as well. Okay, when a juvenile is charged or arrested for an offense, the decision is made whether they ought to go into the formal court system or whether they may be treated differently. They call that diversion, D-I-V-E-R-S-I-O-N, diversion, diversion. And diversion is based upon discretion. If a beat cop, an officer on the street, sees 3 14-year-old boys throwing tomatoes at a factory and they go splat on the windows, they could be charged with criminal mischief. He may round them up and give what's called an adjustment, and they still do that today. An adjustment, and I'm not talking about violence, I'm talking about a stern lecture. Sometimes they bring them to the police station, the parents come and get them. They did that in the 1920s and the 1820s, and they still do it in 2013. Okay? It starts with that original accusation, and the police officer can use discretion, even with adults, but with juveniles it's certainly more of a tradition. A decision is made upon arrest whether they belong in the justice system or in some alternative program. And New Jersey has a couple of those intake kind of screenings where the parents will come, the victim will come. It's almost like a mediation. It's an informal process where the people talk about what happened and the cases just get dismissed at the end. Now, they go by different names. Some of you may be far more familiar with it than I am. I'm sure my colleagues in the prosecutor's office deal with it and know exactly what it is every day of every week. Suffice it to say that it's an informal process where charges that are not that serious don't even go to the court. There's some kind of meeting that's held where the interested parties communicate with one another and the case never goes to court. They call that intake. Up here it says intake departments can screen cases referred to the juvenile court for processing. Nearly half of all cases referred to the juvenile courts are handled informally. Got that? Half of the kids that get locked up, within a week or so, their case is handled in a meeting room and it never makes it to the court system. Many are dismissed. Some of them, they agree to some conditions, maybe restitution, go to class, drug counseling, a curfew. Some people call that informal probation. Kind of makes sense. And if they make it past, the other half of the cases, they make it past informal screening, there may be an adjudication. And there, as we learned, all of the attributes of adult due process apply to children. Right to an attorney, right to the charges, beyond a reasonable doubt, all those things, except no jury trial. There's an adjudication. Now, in New Jersey, even after the trial, let's say the kid's thrown tomatoes, one of them had a prior record. One of the tomatoes hit somebody and injured them. They said, we're gonna go to trial. He doesn't want to plead guilty. Excuse me. Pardon me. You go to trial. He's adjudicated delinquent. He loses. He's found responsible. He did it. Judge adjudicates him delinquent. You can have a diversion here. In New Jersey, you can do what's called a withhold disposition. And the judge says, all right, I found you guilty. But I'm not going to sentence you. I'm going to withhold disposition. And another informal probation. As long as you go to school, if a year from now you don't commit any new offenses, if your parents come in, or a parent comes in, or a caregiver next year, or every 6 weeks, tell us you're doing good, we'll drop the charges. Withhold jurisdiction, disposition. You're familiar with that?
I'm not a lesson worker.
Speak loudly, I can't hear you.
I'm not a lesson worker, so I'm too familiar with it.
Okay. Am I kind of got it right?
Oh no, you got it absolutely right.
Thank you. Good. Now, I told you that during the case, sometimes kids are kept in a jail, in detention, because of the reasons I mentioned twice. And that's what we talk about too. And I also told you that a waiver petition can be filed where the intake officer or the prosecutor believes that this belongs in the adult courts. And from state to state, the process for waiver differs. In fact, the New Jersey process just changed 2 or 3 years ago. Again. Kids can be placed on probation or receive other dispositions. Status offenses are treated differently. Tell me, guess without reading it, what do you think they mean by a status offense? This is something that only a juvenile could do. Truancy. Juveniles can only not go to school. Adults can never be charged with truancy, right? So that's why we call it a status offense. It's not a criminal offense. It's based upon their status as a kid and the fact that they don't go to school. What's another one that happens to kids? Running away, right? Adults don't get in trouble for running away. They may want to do it sometimes, but it's not a crime or a status offense. You can run away. The runaway bride. Remember the runaway bride from a few years back? I guess there's one a year, right? Curfew. Adults don't have curfews, usually. Sometimes they do. Not so much in America. This headline, this title tells it all. Once a mainstay of the juvenile court, confidentiality has given way to substantial openness in many states. For a century, juvenile courts were super secret and private because we want to protect the confidentiality of the child. And it's important to do that. And there are compelling reasons why we did that and still do that, but not so much. You know, we want kids to get something out of this rehabilitation process. You know, if you're humiliated and shamed and the whole world knows about it, it's harder to do good and follow the rules and participate in your rehabilitation. Nevertheless, the media and the people of this country have a right to know what's going on, even in the juvenile system. And even in New Jersey has changed its rules on confidentiality within the juvenile courts. Although I think they're presumed confidential, they may not be. I have to check with my juvenile prosecutor. It's pretty easy to argue that they're newsworthy or that there's an important reason. Pretty sure they're presumed confidential still, but, you know, the standard for allowing the media in and allowing public disclosure is minimal in New Jersey. Kids are fingerprinted now, photographed. They register under sex offender registration laws. We're going to talk about that next week. School notification laws are very common. Schools are notified in New Jersey and around the country. At the end of 2004, 44 states had them. Schools have a right to know when kids are charged with offenses that are involve delinquency. Now, this is a very good article, as you might expect. I believe it is because I'm focusing on it, okay? Some children are handled by federal or state authorities. It depends upon, you know, what the context of the offense is. Obviously, border offenses, if children are not citizens, it may involve federal authorities. You know, it may arise among Native Americans on Indian lands. A child may be involved in offenses there, and it might wind up in federal court.
There was an issue brought up too, not too long ago, questioning when girls are picked up for prostitution, if there's an issue because it's now considered like sex trafficking, not just prostitution. Is it going to be like a federal thing, or can it be local?
Yeah, human trafficking is very important within law enforcement right now. We established a very small unit in my office about 3 weeks ago. And while underage prostitution is a red flag, it's a marker for human trafficking. It's not necessarily always human trafficking, but it's among the markers that we have to scrutinize thoroughly. Prostitution in general, strip clubs, domestic help, you know, servants and maids and hair braiders, and a lot of different things you don't think of when you think of human trafficking. You know, people think, you know, on CSI you see a railway cart full of Russian women that are brought here, and that happens. But more typically, it involves local prostitution and domestic servitude. People that are insecure about their citizenship, who are exploited because of their lack of citizenship and paid an unfair wage or no wage at all, or battered or brutalized, or somehow made to perform things that they don't want to perform and coerced. And it's not always sex. It's lots of different things. But when it involves children, for this class, we're concerned about that, and we're certainly concerned about children who are charged with prostitution. You need to look closely at that situation to see whether there's an adult involved who may be exploiting that child for commercial gain, human trafficking. Anyway, guys, I have to end class early today. Not so early, it's another half hour or so, but you know, make sure you do all of your assignments for next week. I'm going to take, before you wrap things up, let's just take which you should do every day. Let's just take a quick look at the printable course schedule, which is a little bit better. I like this one better. We began today. We talked about the development of the juvenile courts. Not so much about child protective service, although we'll talk a little bit about that. We have many CPS here. We're going to talk next week about mandatory reporting, civil commitment, sex offender tracking, which is important because that involves your next learning project, which is due March 3rd. I would start reading For your Learning Project 3, I would start reading the file soon. And I will teach you about sex offender registration and commitment next week. There's videos that teach you as well. It's not due next week, it's due the following week. But if you want to get a jump on Learning Project 2, even without knowing anything about sex offender risk assessment, you can at least begin to read the file. And it's located within your Learning Project, which I'll click on real quick. Learning Project 2 is right here. When you go in there, there's your upload link, there's your special instructions, and here's my video on how to do this risk assessment, and that plays in your browser. But here's the case file. When you click on that, there's some PDFs. There's things like, I redacted them, I took out the names, like this TREAD update. It's a couple of pages, it's one page really. No, it might be more than one page, but yeah, it's more than one page. And it describes a court-ordered evaluation by Human Services. So that there's a number of documents that are very real documents. Here's a report from the Adult Diagnostic and Treatment Center, which is a sex offender place at Avenel. It's all about this guy who molested kids and his level of risk. And you'll learn how to do that. I'm not saying you need to know that now. What I'm saying is, if you want to get a jump, you can read the police report and read these reports that have to do with the Learning Project. Okay, that's it. I will see you next week.